welcome again to the Law, Policing and Justice podcast, episode 8, and I hope you're all well. My name is Numan Chowdhury and I'm the Supervising Solicitor leading the Legal Advice Centre and lecturer at the University of East London. So in today's episode, we'll be discussing a topic on the road traffic accident for personal injury. We have a very special guest today who is a partner at Hodge Jones and Allen, Daniel Denton. Daniel has been acting exclusively on behalf of claimants for over 20 years in some top-ranked law firms. He specialises in representing claimants who have suffered life-changing and serious injuries and has a special interest in amputation claims, brain head injuries and serious orthopaedic and psychiatric conditions. Daniel also works closely with our Legal Advice Centre. So Daniel, I just want to say thank you so much for everything you're doing so far for our students. They're actually learning a lot from you.
It's a pleasure.
So Daniel, today I will let our students and alumni introduce themselves, and then what they'll do, they'll actually put their questions forward to you. Over to you all.
Hello, my name is Tanya Morgan and I'm currently a master's student at University of East London.
Hi, my name is Fawaz. I'm also a first year student here at the University of East London.
Hi, my name is Alishba and I'm also the level 4 student in University of East London.
Hi, my name is Taz and I am also level 4 student at University of East London. First of all, hi Dan, thanks for coming today. I will be asking the first question to you. How do you or your team begin working on an RTA case after taking on a new client?
Thank you. Good morning. So Hodge Jones and Allen represent people on a no-win, no-fee basis. So the first thing we need to do is we need to send out the conditional fee agreement to clients for them to sign. Now, once the client signed the documents, the next steps are firstly, we need to ask the client whether they have the third-party details of a defendant driver. If they do, we can then carry out a database search to see if their vehicle is insured at the time of the accident. If it is insured, we can then make the claim against the insurance company. Some other steps we also do straight away is we purchase what's called an after-the-event insurance policy. We do that so that the client is covered should they lose the case, because the after-the-event insurance policy covers them for the other side's legal costs and Hodge Jones and Allen's expenses. We also try and request medical records. So we ask the clients to sign forms of authority to request their medical records, which we'll need to use later on in the case when we instruct our own medical experts in the case. And finally, we also need to then start going ahead and trying to obtain the actual evidence to actually prove the claim. So we would have to request the evidence from the police, assuming they attended the accident scene. And the type of evidence that the police would have would be such things as a police accident report, if it had an attending officer at the scene of the accident, CCTV footage they've managed to obtain, or dashcam evidence, any witness statements they've obtained either from either the defendant or even the client, or any witnesses who actually witnessed the accident.
Dan, when we talk about RTA claims, they are very vague as to where they lie when it comes to the expenses. So how do you or the team calculate the value of an RTA claim?
So there are two parts to every claim. There's something called general damages, which is a lump sum of compensation for the pain, suffering and loss of being able to pursue any interest. And we determine that by looking at the medical evidence, independent medical evidence we've obtained, and we then try and use case law and some guidelines to value that part of the claim. The other part of the claim is called special damages, and that's specific losses for any additional expenses the client may have incurred up to now, or even expenses in the future. So such things as loss of earnings claim, either loss of earnings have incurred now or going into the future, maybe some care and assistance where other people, whether it's family or friends or even professional carers, have helped with the client's personal care. So, for example, if he needs help getting out of the shower, for example, or with household chores around the house. There's also other types of losses that they may have incurred. So maybe, for instance, travel expenses, medical expenses, damage to personal property, I don't know, like iPads or mobile phones caused by the accident, or even damage to a vehicle they were driving, which they own. So what we do is we add both types of damages, so the general damages and the special damages, and that's how we value the claim.
So Dan, what step do you take to ensure that you have all the necessary evidence to build a strong case?
Yes, so as I said previously, the first important step we take is we request the evidence from the police force. So each police constabulary have a different type of form they wish us to complete. And what will happen is the police will then provide us with what's called a costing sheet. And there will be a little series of tick boxes where they'll set out what information they have in relation to the case, so whether it's witness statements, police accident report, photographs, dashcam evidence, and you literally just tick the boxes of the evidence you require and pay the additional fee attached to that part of the evidence. Another important step we take is that we try and ask the client if they're aware of any contact details of any witnesses straight away, because in law there's a saying where there's no property in a witness. So either party can basically go out and interview the witness straight away, and you want to be the first person to interview the witness so that you get the witness statement that's supportive to your case before the other side to do likewise. They're the main two parts you do. The other thing you also need to concentrate on is what's called rehabilitation. So at an early stage, particularly on serious injury cases, we'd invite the other side to jointly agree to what's called an immediate needs assessment, or an INA for short. What that involves is that we agree to a case manager going round to our client's home and preparing a report setting out all of our client's immediate treatment needs. So that might be, for instance, psychiatric treatment, physiotherapy treatment, or getting a radiology. So an X-ray or an MRI scan or CT scan. And then what happens is a case manager there then prepares what's called an INA report, setting out their recommendations, and they invite the insurance company to actually fund that treatment. So it's not just a matter of getting the liability evidence straight away, it's also trying to do what you can to give your client access to quick, effective, private rehabilitation treatment as well.
Thank you. So how do you and your team communicate progress and updates to your clients throughout the claims process?
So when we first start the claim, we would always ask the client, which is your preferred method of communication? Is it by email? Is it by phone? Is it by letter? How do they prefer? If they've got any disabilities, we need to make allowances for that. So if a client, for instance, has difficulty seeing, we have to try and arrange for the communication to be on a larger font so they can see it. And we would communicate regularly with the clients whenever there's any particular event in the case that's happening. It's a long process. So what we tend to do is we try and review each file so that the client gets an update once a month, even if there's not much to report in that particular month. Yeah. And there are certain tasks that we set out on our case management system. So each client has got their own separate case on our case management system, and there are certain trigger points on that system where it reminds you to update the client. And we use the method of communication which the client prefers to communicate with them. Obviously, if they try and phone us or contact us in the meantime, we try and get back to them as quickly as possible, say within 24 hours if at all possible, and answer their calls, because obviously you want to try and avoid a situation where the client feels like they have to chase you again. They've got to feel open to be able to communicate with you all the time.
How do you manage clients who may be anxious or frustrated about the claims process?
That's a really good question. So when you first start a claim with a client, there's always an emphasis on managing their expectations. What I like to do initially is I actually tell a client that this is going to be quite a long process. So I said that an average case will take 18 months to 2 years to settle. And I would explain to them that part of my job is to take as much of the stress out of the situation as possible. So I say to them, if there's anything they're worried about, then please don't hesitate to contact me straight away. And I always say to them, I don't mind if they ask me the same question over and over again. I'd rather they carried on ringing me till they properly understood what I was saying, rather than sit there and worry about it. I do explain that it can be a stressful situation, so don't be surprised if there are times where you are feeling stressed, but all you can do is feel free and have that open rapport where they can speak to me, and feel free to speak to me and not feel stupid or not feel shy about speaking to me. Just be open and honest with me at all times, because it's very hard to advise someone if you feel like they're not telling you all the information that's relevant.
Can you tell us, how do you negotiate with insurance companies on behalf of your clients?
Okay, so nowadays the court expects both parties to cooperate with each other and be sensible and reasonable in their conduct towards each other. So I always start off when I'm trying to establish a rapport with an insurance company, or it could even be a firm of solicitors rather than an insurance company, by trying to get on with them. There's a bit of what I would call showboating at the start, where you both try and demonstrate to each other that you know what you're talking about. But once you get over that, you just try and act in a reasonable way, not take petty points. But obviously sometimes you have a situation where you find your opponent's taking liberties. So you have to almost set a boundary, say, well, I might be able to agree to this, but I think there you're just overstepping the mark. So a lot of it is using your common sense and your experience. And then there's different methods. When you say negotiate as well, when it comes to actually negotiating a settlement, there's various different ways you can settle the claim. And I think you have to make a judgment call, not just based on the insurance company or the defendant solicitor's firm you're dealing with, but also the individual you're dealing with. So some individuals, you can be very candid with them and you can set out your position. You say this is on a without prejudice basis. Other opponents, they like to have World War III with you and make a name for themselves. So those ones where I'm a bit more cautious doing that, and I'd set something out in an email so there's no ambiguity who said what to who. And also it depends on the strength of your case as well. So part of litigation is knowing when to hold back because you've not quite got your case ready yet, and when to put your foot down hard on the accelerator because all of your case is ready and you're in a very tough position, so you can push forward really hard. And that's a skill you develop as you gain experience as well. So there's no set way of negotiating with them. In terms of settling the case, we can make offers in writing to each other at any time we wish, or we could have, in more complicated cases, particularly cases that are going towards a trial, something called a joint settlement meeting. And in those sort of cases, all of the parties meet up in one venue and they have a discussion about the case. We see if we can settle the case or at least try and narrow the issues between the parties.
Thank you. So, what factors influence your decision to settle a claim out of court as opposing to pursuing litigation?
Okay, so there's three factors. The first is what we call litigation risk. So we look at all the case as a whole, so all of the evidence in relation to what we call liability, in other words, who's to blame, and we make a judgment as to how likely the case is to win. So we probably put percentage on it, so we think this case is, I say, a 60% chance of winning or a 90% chance of winning, depending on the evidence. So it depends. And there's lots of factors that go into that. So, for example, how good you think your client would be in a witness box? How good are your witnesses? How strong is the evidence? Or is it just one person's word against the other and a judge could believe one person over another person? So litigation is the first part of it. The second part of it is what our valuation is of the case. So going back to the other question, we work out what we think the general damages are. So the lump sum for the pain and suffering, loss of interest. So we look at the medical evidence for that and what we're likely to recover on the special damages, so the other losses. So we have a rough valuation of what we think the case is in our heads. And then the third factor, and probably the most important factor, is the client. So it's the client's case. So if we tell a client, we advise a client not to accept an offer, but they wish to accept it anyway, and they understand it's in front of a final settlement, then the client is king in that situation. It's their case, and we make it clear that's against our advice. We then set it based on what their instructions are. But some clients will say to us, I don't want to go to court. So they are prepared to take under settlements to avoid going to court. But those are the three factors we would take into account.
So how would you handle cases involving uninsured or untraced drivers?
So there's an organisation called the Motor Insurers Bureau, and the purpose of the Motor Insurers Bureau is that they compensate people who have suffered injuries as a result of a negligent driver who is either uninsured or untraced. So, for instance, for an untraced driver scheme, you'd have a situation where a driver causes an accident and runs away from the accident scene and the police are unable to locate them and there's no CCTV or dashcam evidence to help identify the driver. Or in an uninsured Motor Insurers Bureau claim, the driver is there but he's driving an uninsured vehicle. But that actual organisation is known as an insurer of last resort. So the Motor Insurers Bureau will carry out their own investigations just to make sure that the vehicle in question is not insured and that the driver is untraced before they actually decide whether the claim will qualify into the scheme. But you still have to prove negligence against that particular driver anyway.
Yeah.
How do you deal with cases where liability is disputed or shared between parties?
So whenever we have a situation where an insurance company or defendant solicitors deny liability in part or in full, we'd first of all ask for their written reasons why liability is denied in part or in full. We'd reassess the evidence we've got already. Normally they would also provide us with any other additional documentation or disclosure they have in support of their denial or partial denial of liability. We'd review that, and the first step would then be to send all of that to your client and seek their instructions in response to what they're saying, because the client might say, well, that's not true, and I've got a document which shows that's not true. We'd also then consider whether there's any other evidence which the insurance company's not disclosed to us yet that might be favourable to our case. So we may require further documents for us to be sent to us before we can decide whether or not the claim's got reasonable prospects of winning. Once we're satisfied we've got all of the evidence together, if liability is still in dispute, what we'd normally do is seek an advice from a barrister as to the merits of the claim. And we do that partly because our after the event insurance funder would expect us to have taken some steps to protect their position that the claim's still got reasonable prospects of success. So those are steps we take.
So the final question, how do you stay organised and manage multiple road traffic accidents claims effectively?
So again, a really good question. Some of this is because we have automated tasks on our case management system. The way I like to organise myself as well is I like to put any key dates in my own Microsoft Outlook diary, and I also make sure that the same key dates, deadline dates, are also on my case management system as well in case one of my systems fails. So I've got a backup system, and we always keep a note of all of the key dates, and part of the role of being a really good lawyer is to be able to prioritise your work. So we prioritise those deadlines. But as a lawyer generally, you're always planning 6 months ahead in your case because it's quite a long process. When a client comes to see me, I'm not thinking, what position is the case going to be in 2 weeks' time? I'm thinking, what's the position of the case in 6 months' time? Are we going to have the evidence? Are we going to have a liability decision? Is there a court deadline I have to comply with? Because it is, what steps do I need to take now to comply with it? And a lot of it is planning in advance and keeping your own diary. People have got different ways of doing that, but I've sort of found my own way of working, which actually suits me. What really helps me as well is I've got a really good memory. I've got a photographic memory, so that can really save a lot of time. So if clients are ringing up asking for updates, I don't have to start looking at my case management system to see what's happening. I remember where we're at with the case, and so that can also save a lot of time as well. But a lot of it's time management skills and making sure that you're strict with yourself and you keep to your own deadlines. And so, for example, if a court order comes in, you've got to comply with that court order, should really be diarising it all straight away to make sure you don't miss any key deadlines.
Yeah.
And also the other part of it as well is that fortunately I have assistants as well in my cases, so I have a paralegal and also a legal assistant who helps me, so I can delegate tasks to them. So you sort of have to learn to delegate the right task to the right person and learn what their strengths and weaknesses are in order to get the very best out of both of them.
The majority of your team members have like paralegals, or is it like a shared paralegal?
So I have a shared paralegal and a shared legal assistant, what you would call an old-fashioned secretary, who would do a lot of the typing. So my typing skills aren't so fast, but her IT and typing skills are excellent.
Yeah.
So
I suppose that helps you to stay on top.
You wouldn't be able to, if for the amount of cases we deal with, you wouldn't be able to do it on your own. You just would be working 24/7 to keep up. The assistant's invaluable. You need a really good support system.
That's all we have time for today. Thank you, Daniel, for coming in, and thank you to our lovely visitors for putting the questions forward. And to our listeners, thank you for listening in, and we will be back, and do stay connected. Now, if you do wish to get involved with our Law Policing and Justice podcast, please email the Legal Advice Centre at uel.ac.uk. If you wish to explore more on the Law Policing and Justice courses, please do visit www.uel.ac.uk. And as always, thank you so much for listening, and do stay well.